Welcome, everyone, to the Virginia Trial Lawyers Association, the Virginia Employment Lawyers Association, the Fairfax Bar Association Employment Law Section, and the Metropolitan Washington Employment Lawyers Association's October 2025 webinar, Out-of-Court Statements in Employment Cases, What's Admissible? I'm Scott Oswald, and MWELA's Bench and Bar Chair and your moderator for today's program. Before we begin, Jane Lemley from the Fairfax Bar Association Employment Law Section, Nick Simopoulos from the Virginia Trial Lawyers Association, and Josh Erlich from the Virginia Employment Lawyers Association have introductory remarks for us. First, Jane Lemley from the Fairfax Bar Association Labor and Employment Section. Jane?
Thank you, Scott. Hello, everyone. Welcome to today's webinar. I think it's going to be a great one. I am the co-chair of the Fairfax Bar Employment Law Section, along with Daniel Masakayan. It's our first year doing this, and we're really having a good time. The Employment Law Section has about 60 members. We have several seminars throughout the year to provide meaningful content to our members, and we also have some social events to provide camaraderie, and we're looking forward to scheduling some events to get out of the office and maybe enjoy nature a little bit. So happy to be here and happy to be here with my co-sponsors. Back to you, Scott.
Jane, thank you. Next, Nick Simopoulos from the Virginia Trial Lawyers Association. Nick?
Good afternoon, everybody. I'm the chair of the Labor and Employment Section of the Virginia Trial Lawyers Association. It is a real pleasure to be here on behalf of the VTLA, which is also co-sponsoring this great webinar. I want to thank MWELA and Scott Oswald for organizing it, as well as our other co-sponsors, the Virginia Employment Lawyers Association and the Fairfax Bar Association. I did want to take a moment just to tell you a little bit about what the VTLA is. The VTLA is a voluntary bar association dedicated to enhancing the knowledge, skills, and professionalism of trial lawyers throughout Virginia, and is committed to improving law and fairness in Virginia's justice system. Statewide, I think we have about 2,000 members who practice all forms of trial work, including, of course, labor and employment. If you name a practice, we certainly have a member doing it. At its core, VTLA is a three-pronged mission. One, to nurture a professional, cordial, and powerful community of trial lawyers. Two, to educate trial lawyers, and three, to advocate for our clients in the legislature, courts, and administrative arenas. VTLA has a host of committees on which VTLA members can serve and assist in these missions, including a legislative committee and a publications committee. We also have an expansive and, I tell you, wonderful listserv, which allows members to collaborate with each other on important legal issues and even share referrals. I can tell you that personally, I've taken advantage of these benefits many times and found them invaluable. So if you are interested in learning more about the VTLA and benefits of membership, I encourage you to check us out at vtla.com. And of course, you can also call me. With that said, I'll turn you over, and I hope you enjoy this great seminar.
Nick, thanks so much. Finally, Josh Erlich from the Virginia Employment Lawyers Association. Josh?
Thanks, Scott. Hi, I'm Joshua Erlich. I am this year's president of the Virginia Employment Lawyers Association. We are a voluntary bar organization made of plaintiffs' employment lawyers in the Commonwealth. It's a growing organization as our employment laws in the Commonwealth have grown substantially. So we try to put on programs as often as we can, and we have some great stuff that should be coming up early next year that we're still finalizing. And we also have just a critical listserv that is endlessly helpful if you're actively litigating in the courts of Virginia, and especially as more of our practice moves to state court, the listserv, including the VTLA listserv, is more important than ever, as state court includes many mysteries. But that's it for me. Thanks.
Josh, thank you. Now to our participants in today's roundtable. The Honorable Stephen Shannon is a circuit court judge on the Fairfax County, Virginia Circuit Court. Judge Shannon is a distinguished adjunct professor of law at George Mason University. Prior to joining the circuit court, Judge Shannon was a trial lawyer in private practice, litigating complex trade secret and unfair competition matters. Adam Nadelhaft is a partner with the law firm of Charlson, Bredehoft, Cohen, Brown, and Nadelhaft. Adam represents employees in litigation and at trial. Meredith Schramm-Strosser is the shareholder at the law firm of Littner Mendelsohn. Meredith represents employers in employment discrimination disputes and at trial. I'll take your questions throughout the discussion portion of today's program. Just use the Q&A button located at the bottom of your Zoom screen. Let's begin with a primer on Virginia's hearsay rule and its exceptions relevant to employment cases from Adam Nadelhaft. Adam, over to you.
Thanks, Scott. So obviously hearsay and all its rules and exceptions could be hours long, or it could be a whole course if you're in law school. But I'm going to go over this in about 14 minutes. So, and then we're going to have some great discussion. So what is hearsay? It's both, this primer is going to go over both the federal rules and the Virginia rules. And the rules are about the same, about what is hearsay, the definition of hearsay in both Federal Rule 801C and Virginia Rule 2:801C. And hearsay is really a statement that the declarant does not make while testifying at the current trial or hearing that the first party offers into evidence to prove the truth of the matter asserted in the statement. And that's basically the same rule in both the Federal Rule and the Virginia Rule. Next slide. So how do you determine hearsay? There's a few questions. Was the statement made out of court? I mean, that is, was it outside of the current proceedings? Does the statement contain an assertion? Is that assertion offered to prove the truth of the matter asserted? Or is it offered for some other relevant purpose? And if it's offered for the truth of the matter asserted, is there an exception to the bar against hearsay? And that's what we'll be going through relatively quickly here and then into some more discussion. Next slide. So was the statement made out of court? Whenever a witness testifies to words that were spoken by anyone other than during the trial currently being held, the words are out of court statement. So even if a witness is testifying about his or her own statements, if those are statements made outside of the court proceeding, they are an out-of-court statement and would need to either be not for the truth of the matter asserted or fall within the exceptions to the bar against hearsay. Next slide, please. So does the statement contain an assertion? The rules are, again, are pretty similar between the Federal Rule 801A and Virginia Rule 2:801A. A statement can be either an oral assertion, a written assertion, or nonverbal conduct if the person who made the statement intended it as an assertion. So silence can be an assertion. And then the question is, was the assertion made for the truth of the matter? Next slide, please. Now, whose burden is it to show that the statement is an assertion? So, like most evidence, if the proponent of the evidence, the person who's trying to put the evidence on, has the burden to establish the criteria for its admission. But, and this is important, if the party challenging the admission of the declarant who bears the burden of demonstrating the intent. So if there is a question of what was the intent of the statement, it's the person challenging the statement that has the burden. And critically too, the rules of the committee say that if there's a doubt or if it's ambiguous, the rule is the admission of the evidence. So there, it will be admitted if there should be doubt as to whether the assertion is made for the truth of the matter asserted. Next slide, please. As I mentioned, silence can be an assertion. Now, silence can only be an assertion when remaining silent shows an intent to assert something. Most of the time, silence is ambiguous. But, and again, remember, if it's ambiguous, it's going to be admitted. But silence can be considered an assertion. If someone makes a statement to another person and says, you killed that person, and then the person stays silent, that silence can be considered an assertion of, yes, I did kill that person. Most of the time, silence would not be considered an assertion, but there are exceptions to that rule. Next slide, please. Now, what about questions? Questions are usually intended to acquire information, not to assert information. So questions are not usually hearsay, but like everything in law, that's not always true. And context matters. Sometimes questions do contain assertions of fact, or in the language or tone used, and that can be an assertion. For instance, if I was testifying that Joe Smith had a question of, are you saying that I did not see Jane stealing that candy bar? Well, that's a question, but I am testifying that Joe is saying that he essentially saw Jane steal that candy bar. So that question in my mind would be an assertion of fact, and then it would be, is that going to be a hearsay statement or not? Does it fall within one of the exceptions to the rule? Next slide, please. Now, again, the first question is the statement offered for the truth of the matter asserted? And that's the big question. It's hearsay only if it's offered in evidence to prove the truth of the matter asserted. And that's essentially the same rule in both 801 federal rule and 2:801C. When a party claims that it's not using a hearsay statement for its truth, then the court has to ask whether the non-hearsay purpose is relevant, and if it is relevant, is the statement is probative to the purpose that's not for the truth of the matter. If it's not relevant, or if it's not used probative of the other purpose, then it would be hearsay and not admissible. Next slide, please. Now, there are situations where the statement legally is not offered for the truth, like legally operative language, marriage vows, words or offer of acceptance in a contract, slander or libel. Even if that's an assertion of fact, those are not considered hearsay. Mental state of a party, if the statements are used to show that actions were willful or malicious or intent to defraud, that wouldn't be considered a hearsay statement. If the words are to show the effect on the hearer, such as duress or self-defense, that also wouldn't be a hearsay statement. Words to show knowledge of proof or proof of notice are also not considered hearsay. In our employment situation, if I, the employee, go to HR and say, my boss discriminated against me because of my race, that statement is not being used for the truth of the matter that I was discriminated because of my race. It's used to show that the company was put on notice that I was claiming discrimination. State of mind of the declarant is another situation where a statement is not offered for its truth. Next slide. We'll get into the next two slides are Federal Rule of Evidence 801D and Virginia Rule of Evidence 2:801D. And we'll get into this in a little bit, but there are differences here in these laws on prior inconsistent statements and how they're considered under the rules. Under the federal rules, they would be considered substantive evidence. Under the Virginia rules, they would only be used to show bias. But we'll get into that in a minute. So we can go in. These are the text of the two rules, and this is Rule 801D. Next slide. And this is Virginia. This is the text of Virginia Rule 2:801D. Next slide. Now, there are Rule 801D2 categories. This is federal rules. This is statements that are not considered hearsay at all. And this is if the statement is offered against the opposing party and these various categories. And actually, the next few slides are going to go into some of them. But if I have my case against Joe Jones and I am then testifying to a statement made by Joe Jones outside of court, that is not considered hearsay. Similarly, an adaptive statement, for instance, if I said that Joe Jones's wife said he discriminated against me and Joe Jones shook his head, yes, I did, that would be an adaptive statement. And now next slide, we can go into some of the categories. As I said, declarant as opposing party under Rule 801D2A If the declarant is a party to the lawsuit in which the statement is offered, and it's offered by the adversary, that adversary's statement comes into evidence. Next slide. Authorized statement. When a non-party hearsay declarant was expressly or implied, or there was an implication of the party's authorization to act as his agent. Again, there's also a statement for employees when we'll get into that. But it's essentially, for a company, for instance, if an officer is speaking on behalf of the company, that's an authorized statement that person who is the officer as the opponent is speaking on behalf of the company, and that would not be considered hearsay. Next slide. Importantly for our matters, employee statements under Rule 801(d)(2). A non-party declarant is a party's agent or employee. Now here, importantly, the declarant's statement must concern a matter within the scope of his employment, and it must be made during the existence of his employment. And if I'm using that employee's statement, if I'm representing the employee and I'm going against the employer and I'm showing a statement used by another employee of that employer, that statement is not going to be considered hearsay if it was made during the existence of the employee relationship and was in the scope of the employee relationship. Next slide. As I mentioned, there are one big difference between Federal Rule of Evidence 801D and Virginia Rule of Evidence 2:801D is prior inconsistent statements. In Virginia, prior inconsistent statements made by a witness, even if made under oath, can only be used for impeachment. Contrast that with the federal court, where prior inconsistent statements made by a witness under oath or at a prior proceeding are considered substantive evidence. Similarly, in Virginia, prior consistent statements made to bolster the credibility after a witness is impeached is only used for bolstering purposes, whereas prior consistent statements that meet the criteria can be considered substantive evidence. In addition, in Virginia, prior identifications are considered hearsay, while in federal court, prior identifications, even if denied by the witness at trial, are considered substantive evidence. So that's something very important as you're putting on your evidence and getting ready for potentially a directed verdict motion by the opposing side. Next slide. Another difference between the federal rules and the Virginia rules is how it treats statements of the opposing party and its agents, what I was talking about sort of before. In the federal rule under 801E, statements of the opposing party and its agents are excluded from the definition of hearsay, whereas under Virginia rule, it's actually 2:8030, where statements of the opposing party and its agents are an exception to the bar against hearsay. Now, they both come in as substantive evidence, but there is a slight difference about whether it is actually hearsay under the not hearsay under the federal rules, or whether it falls into an exception under 803. Next slide. As I mentioned, Federal Rule 803 and 2:803 has the exceptions to the hearsay rule. The rules are pretty similar, but they are not exactly the same. Next slide, please. For instance, under the federal rules, there are 23 exceptions. Under the Virginia rules, there are 24 exceptions. The most common exceptions are listed here: present sense impression, excited utterance, statement made for medical diagnosis, and business records, for instance. Next slide. And both the next two slides go over Federal Rule of Evidence 8036 and Virginia Rule of Evidence 2:8036, which are business records, which they have here basically the text of the two rules. And it's really important to know those rules, because a lot of your documents in an employment case are probably going to somebody is going to try to have them fall into an exception to the hearsay rule. And it's critical that you know what you need to get that evidence either admitted, or how to argue that evidence should not be admitted. The next slide shows the Virginia rule. And those are the quick primer for now. There's going to be some great discussion going forward. Thank you.
Adam, thank you. Let's begin with the Q&A portion of our program with a discussion of how the hearsay rule and exceptions are applied in practice in general and in employment cases. And Adam, I'd like to turn back to you here and just check in with you about when you start thinking about hearsay. Before you even enter the courtroom for trial, you're anticipating potential hearsay objections. Tell us more about your process of preparing your witness examination outlines.
Yeah, it's critical that you think of these hearsay issues before, as you said, before trial. When I'm making my direct outline, I'm going through my questions and anticipating objections that are going to be made, especially to hearsay, and putting arguments together down as to why the answer or the information is not going to be hearsay. You don't want to, as best you can, you don't want to be totally surprised by the objection and be able to tell Judge Shannon, this is the reasons why this evidence should be admitted into trial. Similarly, in cross, anticipating where the other side is going with their questions and anticipating where I should probably be making an objection to hearsay is also something that I have ready in my outlines. And I have even still to this day an objection sort of cheat sheet, and a lot have the hearsay exception so that I know what I'm sitting there right there at the table so I can look at it and stand up and make the objections when I need to.
Meredith, let's turn to you. Let's bring you into the conversation. You're thinking about potential hearsay objections in the discovery phase of the litigation. Tell us about your thought process in the discovery phase of an employment case, and in particular about hearsay.
Yes, and before, I feel like I need to make a caveat as like the management lawyer here. None of my statements you guys can't use against me in trial. So when I see you guys, just talking for myself here right now. Anyway, I start right in the beginning. So the minute I get the charge, the minute I get the complaint, when I'm doing witness interviews, when I'm doing my internal investigation, I am thinking to myself, what evidence do I need to establish my legitimate business reasons for whatever happened? What do I need to be able to impeach the plaintiff? And is there a way for me to just be able to avoid the hearsay issue altogether? If I can do that, great. If not, then I am tracking that the entire way through and figuring out, like, do I have the requisite groundwork to establish one of the exceptions to the rules? And then, of course, just like Adam said, when I'm finally prepping for trial, I will have case law to back up. If I think a statement's going to come up, I will have case law to use to argue that, either in favor of my witness's statement or to try to get the plaintiff's statement out.
So in a trial, you're trying to categorize as much of the testimony, let's say the plaintiff is trying to get in, as hearsay. Why do you do that?
To the extent that I'm not going to lose credibility with the judge, but yes, because that way I can just get it out entirely. I might try to do that through motions in limine, or sometimes I might just try to avoid the statement altogether just through a stipulation. If I think that there is a particularly damaging statement, even if it's not going to be used for the truth of the matter asserted, like, for example, the actual language that was used when someone engaged in protected activity, if I think I can't take out the sting, I might just see if opposing counsel will agree to a stipulation, and we won't even have to agree to that. But I generally try to keep as much of the bad verbiage outside of the jury's hearing as possible.
So what I'm hearing from you in a particular case, you might actually stipulate, for example, to one of the elements of a retaliation claim that the employee engaged in oppositional activity with the employer merely because you don't want the sting of the statement coming in. Is that it, or is something else?
Yeah, no, exactly right. I mean, if the protected activity is an email that is just inflammatory and has gruesome descriptions of, an event or words or, what's been said to the plaintiff, and I don't think I'm going to be able to have a limiting instruction actually distance my client from those statements, then I will I will evaluate whether or not, and if I'm certain that this person has engaged in protected activity, then it might just be worthwhile to just put that one up to a stipulation and not have those inflammatory words visible to the jury. Because as we all know, limiting instructions are what they are. You can't unring some of these bells.
Thank you. Adam, from an employee counsel perspective, when you choose to do so, how do you argue that a statement is offered for a non-hearsay purpose under 801 2:801C, such as to show notice, effect on the listener, or motive? How do you make that argument at trial?
I found it a lot of times these arguments are made at the bench more often than not, at least in Virginia courts. I found that it is not made in front of the jury. So then we are, telling again, Judge Shannon, and me and Meredith go up and we're talking to Judge Shannon, and that's where I'm saying, this statement that my client made to HR is not being used to show that it was that he was discriminated against for the truth of the matter that he was discriminated against. It's used to being shown that he's putting the company on notice that he was being discriminated against, and that's one of the elements of a retaliation claim, or that's the state of mind. I would, in these types of areas, I think it's probably better, if possible, to have those discussions in front with the jury not hearing it, going up to the court, up to the bench. If not, I would just make I'd be prepared to make that argument and be prepared, as you're making the argument, if you're making the argument where the jury is hearing you, they're listening to those things too. So if you're saying this is to tell, I'm telling the judge, but the jury is hearing as well that this statement is putting the company on notice that he complained about discrimination. So that's how I would do it.
Judge Shannon, I'd like to bring you into the conversation with us at this point. If a proponent of an out-of-court statement is offering the statement for a non-hearsay purpose, such as to prove effect on the listener or knowledge by the listener, as an example, how should the attorney articulate that purpose at trial? Let's assume first it's a jury trial.
Adam's point is a good one. From a judge's perspective, you don't want the attorneys coming up to the bench too much, but if it's a significant issue that you think is going to be a recurring issue and is really important in the case, a judge is going to allow the attorneys to approach the bench once, and I'll turn on a noisemaker and I'll hear from both sides. And it's good to do that because what a judge has to be mindful of is you don't want to taint the jury if the jury is a trier of fact, but also you don't want to taint the witness, right? And so what Adam's saying is a good point. For smaller hearsay type matters, I just prefer people stand up and say, Judge, I'm going to note an objection for hearsay, and let the other side say why it's not hearsay. It may be that the other side hasn't really thought through the issue. It may be that the person who's standing up and saying this is hearsay, it's not really hurting the client, but you just kind of want to set the precedent that I'm not going to let you do this all day, and I'm going to test you a little bit. And it also gives you an opportunity to read the judge. But the point is, if it's a major issue and it's hearsay, ask to approach the bench, and then the other side might want to say, Judge, would you please note my objection, but also could this just be a standing objection so I don't have to continue standing up and disrupting the proceedings? And a judge is going to appreciate that. Adam, I think you would agree with that, right?
Yeah. Yes, definitely. And I also, if I was making an objection and you were overruling my objection, I would not want to keep standing up in front of the jury and having you continuously overrule my objection. I think the jury is going to be questioning what I'm doing and thinking and not looking at, and I'm not getting credibility with the jury. So if I can say, Your Honor, I have a standing objection to that, and it's going to be throughout the trial and throughout those questions, I think that is really helpful so that I don't have to keep standing up and getting overruled, because I do think a jury could start to look down on that against me and against my client.
Judge Shannon, should the lawyer, if they know that it requires a nuanced explanation, should they ask you to come up to the bench and do it with a husher on, or do you really want that coming from you to bring the lawyers up to the bench?
That's tricky, right? Because as a former litigator, what you don't want is for there to be a jury and to say, "Judge, may I approach the bench?" And the judge says, "No, you cannot," because then it looks like you're having an issue with this judge. And all things being equal, jurors tend to be very deferential to the judge. And so if there's an impression, whether it's deliberate or not, that the judge is having a problem with this attorney, that the lay people who are the triers of fact may start thinking, "Oh, that's the good attorney, and this is the attorney who's got a problem." So it's tricky, right? It's a little obviously, if it's a bench trial, the only concern you have is tainting the witness, and so it's I think a judge is a little more, if you want to approach that's fine. What I don't want is jurors to kind of wonder what's going on, and then they start talking to each other, and it looks like the room is kind of falling apart. So if you want to approach the bench once or twice because it's a big deal, that's fine. But that shouldn't be your go-to, right? You should just stand up, state a concise objection. The other side can give an explanation and leave it at that. Just save it for the big stuff if you want to approach. Or right before trial, you could do a motion in limine, right? And say, "Judge, I would just," when we got the witness and exhibit list, we noticed that there was an objection to certain documents. There's a significant hearsay issue that's going to need to be resolved outside of the trier of fact. If you want to address it now, that's fine. If you want to wait till the trial happens, that's fine as well. I just want to give the court a heads up that at some point we're going to have a couple minutes to argue this back and forth. And I think that's fine as well, because you're not tainting the jury and you're not tainting the witness in that situation.
Let's take our first question from the audience. And Meredith, I'd like to pose this to you. If you would, as best you could, reverse roles with employee counsel, why would you as employee counsel stipulate to the non-admission of that evidence and agree to a stipulation, let's say, on protected conduct? If you could give your own thought process of the things that you say to convince employee counsel, this actually might be in their client's interest.
If I put my plaintiff's lawyer hat back on, probably not. But if there is a situation where that statement is going to open my client up to credibility attacks, if the statement is not clear cut, if it is muddled, if there is a way that it also cuts against, my client in a way where that is an area of weakness that I'm concerned about, it might be worthwhile, for the sake of excluding that possible credibility attack, to just say, you know what, we've now, that's one less element to establish. We've got it. It's done. And we can now go forward to the meat and potatoes of what we have going on, which is the causation element. But if I'm back on the plaintiff side of things and I have a really good statement that's horrible, I'm probably not going to agree to it, because I want the jury to have that emotional reaction to whatever it is that's being said, even with a limiting instruction.
Appreciate your candor. Let's talk about prior inconsistent statements of a witness. Meredith, back to you. How do you use prior inconsistent statements by a witness for impeachment purposes under the Virginia Rules of Evidence?
So I'll be very careful in which ones I really want to go after, right? Again, I want to pick and choose what's going to be the most impactful. So if there are inconsistent statements about timeline, about who said what, about when, I just said timeline, but the main things are, what is the content of the statement? Can I undercut a previous version of what this person purportedly reported? Can I undercut the person saying that, yes, at this time I was at this place and I talked to this person? Those are the really important ones that I'm going to want to try to focus on. There's nothing more like frustrating than an attempt at impeaching a witness that's just going nowhere and falling flat. So I want to make sure that whatever impeachment I'm doing is really going to accomplish my goals of making the jury wonder about just how credible this witness is.
Judge Shannon, when a proponent is offering a prior inconsistent statement for impeachment purposes, how should the proponent adequately lay a foundation to then impeach that witness?
Well, the nice thing about the rules is that with 2:613, it's very mechanical and it's well laid out. I oftentimes will hear an objection when there's impeachment. Judge, this is an improper form of objection. And they're just going about it the wrong way. For example, they don't present the witness with the time and the place of the statement that was supposedly made. The rule calls for you directing the witness to that. And then if the witness denies it or doesn't recall the statement, then you can, for example, use extrinsic evidence. And the rule documents how you do it. What's really nice from a judge's perspective is if the lawyer will say, Judge, I'm proceeding pursuant to Rule 2:613, because the judge could just open up the book and follow it. And so that's how I often will see this thing play out. Judge, this is an improper form of objection. I'll say, okay, counsel, what's the rule? They'll refer me to the rule. I'll read it. I'll say, if anybody needs to see the rules, I have an extra copy here, but I do sustain the objection. That's how it usually and also the point is well raised that the statements normally are being done for impeachment rather than for the substance of what's being said. You need to actually have a rule that would support it, like a party admission or a statement against interest, in order for it to come in under the state rules for the substance of the matter. So, and I think that was alluded to in Adam's talk earlier.
So, Adam, since in Virginia, prior inconsistent statement can only be used for impeachment purposes, how do you go about having a witness maybe adopt this statement so that you can cite to the statement when resisting a motion to strike following your case in chief?
Yeah. So many times if I've impeached the witness, so now I have the impeachment, but a lot of times that I found that the witness is embarrassed or feels like, oh, I've been caught. So then I would ask the question again substantively, without the prior deposition testimony, ask again, whatever the question is, did Mr. Jones give you the notice that he was discriminated against? And many times the witness will now say, yeah, he did. So now that's substantive testimony. So now I've gotten two benefits. I've impeached the witness, and so the jury is questioning that witness, and now I've got the substantive evidence, hopefully, that the witness is now saying, yeah, that did happen. So I think many times if you can get the witness to now sort of go back and adopt the statement they made the first time that you're impeaching them with, that's how you try to get the substantive evidence in, that you can now say, yeah, see, HR admitted here after being questioned, after being impeached, but then admitted that yes, they did give the notice. That's how I would do it.
Let's turn to prior consistent statements. So let's take the scenario where you want to bolster your client's credibility using a prior consistent statement. Let's say after Meredith has impeached your client. How do you do that?
Well, then it would be so then it's not always easy, because you have to follow the particular rules, but you would use the evidence you would say, you would show them the statement, let's say they made at their deposition, and it's consistent with what they've said, and that it is, you would say, and you did this, and you said this before this other thing happened, to try to bolster the statement, to show that, yes, that is a consistent statement, that what you said was true now and was true then, and that there might have been this inconsistency that Meredith showed, but now I'm able to show through deposition testimony or otherwise that you've made the same consistent statement previously. And in Virginia, again, that's not going to now prove substantively that what you've said is correct. It's just used to bolster his testimony. Whereas in the federal court, the jury, at least they probably won't, but can consider it as substantive evidence. And then I'd probably ask the person again to say whatever it is that again bolstered the statement, so that it can be substantive evidence as well.
Meredith, let's take a situation where you've got a corporate representative who has been impeached, maybe with their deposition, but you've got some documents that are indicate that they have made a prior consistent statement in those documents. How do you then use those documents as a prior consistent statement to bolster your witness?
Purely from an impeachment standpoint, or also trying to get things, if I can get things substantively and through a business exception, that'd be great, right? Because then I can do it both ways. But again, like if I will hopefully have figured out all the pitfalls and potholes before this witness gets on the stand. Of course, no one's perfect. Something's, devolved. But, on redirect, right, I'll try to figure out a way to correct it. If I can establish a basis to use extrinsic evidence, I will. But ideally, if I can't get it on a cross of my own witness, I will deal with it when I bring them back up, when I call them as my own substantive witness, to get those statements affirmatively out that way.
So you'll actually call them in your case in chief, and you'll go over that territory again in your case in chief to bolster them that way.
Exactly.
Is that it? Judge Shannon, when do you most often see a proponent offering a witness's prior consistent statement most effectively?
Well, the scenario is somebody makes a statement in court, and then the other side is waiting for it, and they directly contradict what's being said. And so I understand what's being said. I'm going to wait till it's my case in chief. But I also see somebody, if they have the information readily available, what they want to do is they want to introduce what could be considered an inadmissible self-serving statement, but it becomes admissible because it's a prior consistent statement. And the way it's phrased in the language of the law is that, the statement had to have been made before the bias existed, right? So, so if you could do it, my view is that jurors try to size up people in real time. And so if there's a witness who is shown to be a liar under oath, you probably want to clean that up as quickly as possible to try to dispel the notion that, hey, I forget that guy's name from yesterday, but that guy was a complete liar. Did you see the attorney just present that document? That's what you do not want happening in the jury deliberation room. So I think if you kind of view that as one, like a vignette, one episode where you want to make sure that the jury doesn't think the witness is a liar with that impression, as opposed to waiting until, I'll fix this when I recall the witness. That sometimes might be the strategy. I'm not saying the other way doesn't happen, but I'm just saying if you realize that a pie just got thrown in your witness's face, you probably want to clean that up immediately so the jury's not thinking that's the guy who's got pie all over his face, right?
I hear you. We're all smiling because we've all been there before. Let's turn to limiting instructions. Adam, if the court admits evidence for a non-hearsay purpose, under what circumstances do you seek a limiting instruction?
Well, yeah. So I think if it can be used, if you can get the limiting instruction that's saying to the jury, that this should not be, thought of as for the truth of the matter asserted, but for something else. If I can get that limiting instruction, I think that's very helpful, because now the jury is hearing this statement came in, but not for the truth of the matter asserted. To me, if I'm, juries, as Judge Shannon said, are mostly lay people who don't, so now they hear, oh, this statement is, I can consider it, but not for the truth of the matter asserted. That seems to me, if that's what I would want that limiting instruction. So if I could get that limiting instruction, something like that, yeah, I would certainly ask for it. Again, I'd want to pick and choose. If there's a lot of, hopefully I'm not objecting all the time, for the reasons we've talked about before, and getting overruled. But especially if I also am getting overruled, it'd be good to get the limiting instruction so the jury sees that I'm credible, that there is, yeah, I made that objection. Yes, I didn't get exactly what I wanted, but I'm also getting some instruction to the jury that they should only consider it for this purpose. And again, if they're being told you can't consider it for the truth of the matter asserted, but only consider it for this, I think that's a big win if it's for some issue that I'm looking to at least, if not exclude the evidence, at least temper what the evidence is coming in for.
So what I'm hearing from you is that you're asking for the limiting instruction in real time, in that moment when the evidence is coming in.
Yes, I would, because I think it's important that if we're in a week trial and that evidence came in, day one, and nothing is being said about that evidence in terms of limiting it until the last day, that's going to taint the jury. In my mind, that's going to taint the jury for the next 4 days while they're considering that evidence for the truth of the matter asserted. And now you're telling them at the end, hey, by the way, now don't consider it for the truth of the matter asserted. Remember that email. And they very well might remember that email if it's an important email, but now I would like for them to know that from the beginning of you're not considering that for the truth of the matter asserted, and have that knowledge that's in their head the entire time rather than at the end.
So Judge Shannon, if the evidence, you've admitted the evidence for a non-hearsay purpose, do you routinely give the jury a limiting instruction when you admit the evidence?
Yes, with a caveat. So we're dealing with a jury trial, so I'm always going to tell the jury up front that they are the triers of the facts, and I am the trier of the law as a judge, which means that I need to make legal rulings. And I explain the rules of evidence, and I am explicit in telling the jury, do not penalize the attorneys for standing up and respectfully making an objection based on the rules of evidence. They're simply trying to see to it that the trial is being conducted in an orderly way. And I say it's my responsibility as the judge or as a trier of law to rule on the objections. And so I explain to them, when I sustain an objection, that means I agree with the objection. If I overrule the objection, it means that I disagree and the question can be answered, or you can consider the answer that was given. If there is a hearsay objection that is sustained, I might initially turn to the jury and explain what the nature of the objection is, what hearsay is, because most non-lawyers, they don't know what that means. Going forward, I'm not going to continue translating what the objection is. I may ask an attorney, if an attorney says, Judge, this is not actually hearsay, this is just to prove the effect on the listener and what happened next. I might try to rephrase what the attorney just said to me, and I say, okay, well, I will overrule the objection because the statement is not being used for the truth of the matter, but simply to show what happened next. You ma'am, sir, you may answer the question. I can do it like that, and then the jury can just kind of watch what's going on and continue with the flow of the trial. Does that make sense?
It sure does. Adam, let's take a question from the audience. What's an effective way to get a hearsay statement in to show the effect on the listener in an employment discrimination case?
Well, I guess it depends on the facts of the facts. Did the statement have the effect on the listener? Meaning, so if I was to come in and say, I made the statement that the person had to take the yarmulke off his head, and then the person did take the yarmulke off of his head. That the effect on the listener is not the fact of taking the yarmulke off his head, but that he got the statement, and then he what was the effect of that happening? I mean, it's all based on context. There's going to be statements and things that are hearsay. And you can try to argue, you're going to try to figure out your best arguments if that's a great statement to have it come in. But there is going to be times where no matter what you're arguing, it's hearsay. It's an out of court statement that doesn't fall within any of the exceptions. So you have to, but that's where you're trying to plan out. I think the biggest thing you want to do is if you have you're looking through your evidence and you have this kind of killer evidence, you want to make sure, okay, I know the other side's going to object to this as hearsay. What's the best way I can do? What are the best ways? Because you might be able to argue it a few different ways. There might be one way that Judge Shannon doesn't agree with and thinks it is hearsay, and there might be another. But I could say, but alternatively, there's this. Now, if I'm going to alternatively, they might think I've already gotten past my best argument. But anyways, I would think of all the ways you want to get in that evidence prior as best you can. Your best evidence, you want to have rock solid that you can get into evidence and be ready when they say hearsay to say, no, it's not here. It's either not hearsay or it falls into within one of the exceptions.
Let's turn to exceptions to the hearsay rule. Judge Shannon, which hearsay exceptions under the Virginia rules 2:803, 2:804 do you most frequently see invoked during jury trials?
Well, as we talked about earlier, there are a lot more for 803 than 804. 804, just in case anyone doesn't have the book with them, that's when you've established that the declarant's not available. But so I see 803 objections more than 804. Business records obviously are sort of bread and butter. Party admissions, those are big. With medical malpractice cases, learn treatises. I see that. Just point out, you'll get it's fact specific, but you'll get a present sense impression sometimes, usually more in criminal cases, or an excited utterance. There was a list at the beginning when we were going through the rules that kind of lists the most common ones if anybody wants to refer back to it. But those are the ones that I will routinely see at trial.
What's the difference, Judge Shannon, between an excited utterance and a present sense impression under the Virginia evidentiary rules?
Well, they both have a degree of spontaneity. An excited utterance is, "Ow, you just ran over my foot," right? It's real time, and it's sort of something that just comes out of you. You're exclaiming something. Whereas a present sense expression, there's also a spontaneity, contemporaneous component to it, but you're describing something that happens. For example, somebody's calling 911, and what's your emergency? There's loud banging on my door. It appears somebody's looking through my window right now. That is, you are explaining something that is going on right in front of you, and the idea with both of these is that there's an indicia of reliability, and so these out-of-court statements can be offered for the truth. "Ow, you just ran over my foot," because it is so spontaneous and it's an exclamation that it's probably not contrived. So that's the idea. There's a common component of spontaneity, but one is you're describing what's going on, and the other is you are exclaiming because something has just happened.
Let's turn to the business records exception to the hearsay rule. Judge Shannon, what specific foundation do you expect counsel to lay before you will admit a business record under the business records hearsay exception to the Virginia rules of evidence?
Yeah. So with the nice thing about Virginia and our scheduling orders is that our routine scheduling orders say you've got to give your witness and exhibit list 15 days before trial. So trial by ambush is disfavored in civil cases and just disfavored, period. But in a civil case, the attorneys are going to know what the other side is trying to introduce. And so if somebody is going to object to a certification, for example, where you can just certify instead of bringing in the custodian to authenticate, well, this is probably not something that's going to be fought. If somebody is objecting to the certification, which needs to occur before trial, 5 days after you give notice of your intent to use certification, well, at that point, the attorney can say, okay, this might be a fight. So I need to bring in my custodian of records. If I don't have a custodian, do I have a knowledgeable witness who will satisfy the test? And then you just work mechanically down 803.6. So is the record, is it kept in the ordinary course of business? Is it with regard to the facts? Remember, one thing I want to point out, with business records, opinions that are in those documents don't come in. It's the facts and the events that are described by somebody with knowledge. And so I sometimes see that, right? Somebody's final opinion with regard to the facts contained therein, that doesn't come in Virginia. But is this a custodian of the records? Are they kept in the ordinary course of business? Was it regular practice to keep this kind of document? And were the facts that are stated in there, were they memorialized near the time of the writing by somebody with knowledge? The rule itself tells you what you need to do. The key is to make sure you have the right person at trial to make sure you can get it in.
Let's talk about the right person. Do you require a party to call a custodian of records formally, for example, to invoke the business records exception, or will a high-level executive of the company do?
Yeah, the rules don't say it. It has to be the custodian of the records, and also for authentication purposes, it's actually much broader. But the key is in Virginia, you could just do a certification in lieu of bringing in the custodian. And if the other side is not objecting to the certification, it's pretty clear this is not going to be a real fight at trial. In my experience, it's only when somebody objects, and then you've got to scramble and make sure you can get the custodian or somebody else who would satisfy the test, that this is going to be something that we're fighting about at trial.
Adam, there are times when you challenge an employer's attempt to admit their own records under the business records exception to the hearsay rule. Tell us about that.
Right. I mean, just because the document comes from the company doesn't mean that it's a business record. As Judge Shannon was saying, there's a lot of prerequisites that need to be met to get that document in as a business record. And so, I want to make sure that the company, I want to make sure that the company is doing what they need to get that document in. The other thing to be really aware of is that, as Judge Shannon was mentioning, just because the document can come in as a business record, there could be multiple layers of hearsay. So it might meet the business record exception for the overall document, but are the statements within that document, are they hearsay? Are they opinions, or are the statements made hearsay? If it's a something where it's like a printout of like just numbers, that's probably not going to be hearsay. That's probably going to meet the business exception rule. And if someone can show, and if they can meet all the prerequisites to get the document in, that's probably going to be difficult to challenge. And I probably would just agree to it and not make a big deal out of it, and try to then either show the jury why they shouldn't consider it, or that it's just nothing. If it's a different type of document that has statements or other things in it that are hearsay within the hearsay, then even if the document itself comes in as a business record, I would ask that there be potentially redactions made to the document that would take out the hearsay. And if I can get that would be very helpful, because now the jury is seeing, oh, there's this business record, but there's information in here that's hearsay, and they can't consider it. I think that's helpful. So that would be a way I would challenge it if I can't do the ultimate challenge of not getting the document in under the business record exception.
So let's take an example. What you think as a self-serving employer conducted investigative report, for example, or employer authored investigative report. When thinking about maybe excluding either that in whole or in part, break it down for us. What's that thought process look like for you?
Right. So that investigative report, I would say I would try to keep the whole thing out. I would say that I would argue that it's not done in the normal course of business. Now they might, depending on the company, they may say, well, we have investigators. That's their job. Their job is to do these types of investigations. But typically what those reports have are just that person's interviews with a whole bunch of employees or other, and so all those statements are hearsay. I mean, those are all out of court statements, and likely, and they're the statements of the employer or the employer's employees being used by the employer themselves. So it's not a case where I'm using the report against the company. It's the case of the company trying to use it itself. And I would say those are self-serving. They don't show, they're not necessarily going to be truthful. And I would definitely try to keep that whole thing out, because whether it's a regular course of business to do the investigation, whether that's their regular course of business, all of those interviews are all hearsay, are all out of court statements, and they're all being used to show the truth of the matter asserted. So I would strongly argue that the whole thing should be excluded. And that is one of the ones where I think Judge Shannon mentioned it before. An investigative report like that, I would probably almost 100% do a motion in limine first before trial to try to get that document excluded before the other side even brings it in front of the jury, because I don't want the jury to even hear that there was an investigative report if I can get that.
Let's turn to the public records exception to the hearsay rule. Meredith, when a party offers records prepared specifically for litigation, like a Virginia Office of Civil Rights, a finding of cause or a merit finding, how do you assess the document's admissibility under the public records exception to the hearsay rule?
I think it's similar to the approach of, the investigative report done by the employer. Of course, when they're trying to do the right thing and figure out what actually happened, like they always do. But those investigative reports are no different, right? It is just an investigator summarizing facts that they found during the course of during the course of their investigation and summarizing those. And so, I similarly, if it's and definitely if it's a finding of of course it's gonna be a finding of cause. Why else would you use it? But definitely be trying to get the conclusion excluded. If the report's going to come in, then at least get it redacted. But to again approach the whole context of okay, yes, there is a document, but how much of the actual meat of that document can I still get excluded as hearsay within hearsay, especially statements by the plaintiff.
So, Adam, let's turn to another question from our audience, and it relates to the investigator's version of the interview with your client. As an example, the document you get in discovery, your client says that's not what I said, or the investigator only put half of what I said down on paper. How do you approach the admissibility of that type of statement that the employer is asserting your client made in the moment?
Well, that's where that is, if the employer is likely going to be able to get that statement in, because now it's a statement used against their opponent, and the opponent being my client. But where then I would be trying to, probably in discover or otherwise, making sure that I got all of the notes of the investigator, trying to figure out the process that the investigator used, and there I'd probably be calling the investigator to the stand to talk to him, and getting and trying to establish that you either didn't take down everything he said, you selectively decided what to say. And then I would probably, if I knew that evidence was coming in, I would also probably even have my client talk about that interview and those notes even in direct and say, listen, this is what, knowing that's coming in, saying, okay, you gave this interview with Joe Jones, and he says you said this. Did you say that? And have him say, no, I never said that. I strongly deny that. And that, I think, the best way to attack it. So that's where, again, where if you can make a motion in limine in the beginning or have a clear sense of that evidence that's coming in, I might not be able to exclude it based off of argument or hearsay, but I'm going to use other means to attack it. I think that's the best strategy, either through crossing the investigator or even using your own client to sort of affirmatively take the wind out of the sails of the other side.
Judge Shannon, let's take another question from our audience. How is the treatment of an out-of-court statement made in emails treated differently than just let's say, an oral statement as you're thinking through it from the bench?
Well, at Fairfax, we do so much family law that I see this all the time in the form of text messages between couples. So sometimes it's emails, but these days a lot of it's text messages. I think it's somewhat having something tangible in front of you, at least from my perspective, is easier to digest when it's a bench trial as the trier of the fact, as opposed to just oral statements going back and forth. But the analysis for hearsay is the same, unless a rule tells you that the mechanics are a little different. So, going back to the impeachment discussion, for example, if you're impeaching somebody on a prior consistent statement with extrinsic evidence, the rule speaks to how you go about doing that. But the analysis, generally speaking, between hearsay that is oral and hearsay that's in writing is, all things being equal, is relatively indistinguishable.
Meredith, let's take documents in native format. Let's say it's a spreadsheet and it's coming into evidence, for example. Is the document's metadata also admissible?
Well, it depends on if it helps me or not. I would argue no, right? It is because that is separate, statements by the computer system that is being made, right? It is not the substance of the document, but oftentimes if we're getting into an argument about where we are dealing with metadata, Excel spreadsheets most often are going to be produced natively just because they're a pain in the butt to deal with otherwise. But if we're dealing with other things where there's metadata, usually there's a reason why, right? We're arguing that document is not authentic, or there's an issue about the timing of when that document was made. But I am definitely going to be making an argument that that data in and of itself are separate statements by that system, and that those should be evaluated as such as out-of-court statements.
What if it's your own document, so it's your client's spreadsheet? Does that change the analysis at all?
Well, that I win is it's going to be a different event. But I would be trying to establish it I'd be trying to lump that into the business records foundation, right? So I'd be trying to demonstrate that, either this is part of how we show that this is a regularly produced or a regular practice, or this demonstrates how this is stored or conducted in the regular course of business. Or if I can't do that, then I'm going to have the person who created that document walk through the steps of what they did and how they did it and when they did it. And then that way, even if I can't get the metadata up, which again, a visual is always extremely helpful in just having someone explain it, but that way at least I will get those facts in. But I would say that the metadata is a separate statement.
Okay, got it. Let's take some common scenarios where there are hearsay objections in an employment case. And Meredith, I'd like to start with you. If employee counsel seeks to admit the employee's own complaint to his supervisor as evidence of that his employer was on notice of his complaint of discrimination, is that email, that notice, is it admissible?
If it is only being done for the purpose of demonstrating that they informed the employer that they believe they're being discriminated against for that protected activity event, for that disclosure, then most of the time I would say that yes, it is. Again, if it depends on what's in that document, and I'm going to try to figure out ways to either limit its exposure. If I know it's going to come in, that is something that I'm going to try to work with opposing counsel with in advance, so that we can either both agree that there's going to be a limiting instruction, or if they won't, then I'm definitely going to be right there ready for a limiting instruction. But I mean, if that really is not being used for the purpose of the plaintiff saying, here, proof that this person discriminated against me on the basis of my protected class, then that is something that is going to come in. And I do not want to be making objections and making things seem like a bigger deal if I know they're going to come in. I want to demonstrate to the jury that I am not afraid of this statement, that I know it's there, and don't worry, we're prepared to deal with this situation. The last thing I want to do is try to make a bad statement even worse by seeming scared or making a big fuss about it.
Is your answer the same if the employee is submitting the employee's own complaint to your company's human resources department, consistent with, let's say, a policy that your employee
yes, because I mean, under virtually every one of these statutes and these laws, I mean, the manager, if they meet that test of being a supervisor, right, where they have an obligation to act on behalf of the company and their knowledge is imputed to the company, right? The same thing for HR. If you're in the HR department, that is your job. Your job is to evaluate these things and to deal with these things. So those two aspects are going to be, the analysis is going to be the same. If there is a way that I can argue that a manager is not really a manager under the applicable tests, then that might be a different situation. But with HR, again, if it's more likely than not going to come in, I'm going to plan in advance on how to diffuse whatever bad stuff is in there, and just have my witnesses ready and prepared to deal with those really hard questions.
Let's talk about the situation which happens, and after that, where there's some back and forth between, let's say, the human resource department. If employee counsel seeks to admit the employee's response to, let's say, the HR department's request for more information supporting the discrimination complaint, is that those communications back and forth, are those admissible?
If we're talking about the plaintiff statements, I mean,
yes.
if the plaintiff statements, for example, let's say my HR department reaches out and says, thank you, we take your complaint seriously. We want to set up a time for interview. We want to see these text messages. We want to do X, Y, Z. If they're being shut down, absolutely trying those statements in, and most likely under the party admission statement by a party opponent exception, because to me that is a major point of credibility. If somebody believes they're being discriminated against or retaliated against, I'm going to be arguing to the jury that they're going to be backing that stuff up. And so if they don't, I absolutely want that to be in front of the jury to demonstrate and to support my argument that these are not credible allegations.
And by the same token, if the employee does back up his statements with a response, a fulsome response, that would be admissible as well?
I mean, I don't see how I can have one with, it'd be a goose gander situation. So, but I mean, candidly, I mean, again, I might try on different grounds. I might try to limit what is actually visible. Yes, the person proffered XYZ evidence. Yes, they had a witness interview. Yes, they, proffered additional witnesses for HR to talk about, but then try to limit the substance of what is conveyed in that statement. But I try to think very strategically and importantly that I'm not going to be taking inconsistent positions, because I think that is something that a jury is going to look upon, especially if a judge points out that, or opposing counsel points out that, I made the exact argument, a different argument just a few moments ago in support of my own witness or my own documents. So I really think through those things very carefully to try to figure that out.
Adam, if an employer is seeking to offer a statement by, let's say, your client's coworker accusing your client of misconduct, are you objecting to the admissibility of that as hearsay?
Yeah, I think so. I mean, it seems to me that that's another out of court statement that's being used for the truth. They're trying to use that that my coworker's statement to say that my client did something wrong. I don't see an exception to that rule. If they want to have the employer say, the coworker say that my client did something wrong, have the coworker come up and testify what he saw, and then that would be different. But if it's a statement made to HR that said my client did something wrong, that doesn't seem to fall into any of the exceptions. So yeah, I would certainly say it's hearsay, and it's not being used to put the employer on notice of protected activity or anything like that. It's being used, in my mind, for the truth of the matter asserted.
Judge Shannon, if employee counsel seeks to admit, let's say, an out-of-court statement by a company manager that the company needed to remove the employee who was too old, let's say, what questions might you ask before admitting that statement?
Well, first I'd wait for an objection, right? It's not my job to do sua sponte objections, and I think it can exhibit bias for or against parties. So I need to hear the arguments, but at least in terms of the law, I'd want to have a sense of what level this person is within the hierarchy, such that it could be attributed to the employer, or it's just someone's individual opinion, and that someone is not being sued in this case. And so I think that's the path that the attorneys would be leading me down. Can I go back to something Meredith said just a minute ago, which dealt with kind of if you've got a document that's bad, and you're not sure how to do damage control with keeping it out altogether. She's thinking of strategic ways to minimize harm. And one of the things that you might want to consider is just telling Judge, we'll stipulate to the fact that the complaint was made. The problem we have is that the statement they want to get in is so self-serving that it goes well beyond proving up that a complaint was made. It really gets into a 401, 403 analysis where the probative value is so substantially outweighed by the prejudice just due to the voluminous nature of the self-serving statement. Again, Judge, we'll stipulate that a complaint was made and even a summation of what it is, but this respectfully goes beyond the pale of what should be admitted to prove that point. So anyways, I diverted, but what I'd be doing with regard to the initial thing, trying to figure out based on the attorneys, what level is this person within the hierarchy such that I can attribute it to the organization that's in the litigation itself.
Let's turn to performance evaluations. If management counsel, Judge Shannon, seeks to admit let's say the employee's performance evaluations to show that the employer was justified in firing the employee for underperformance, what questions, if you get a hearsay objection to the admission of that kind of performance evaluation, what questions might you ask management counsel before you rule?
I want to distinguish within the document what is a fact or an event that would have been within the observation of the writer versus what is their opinion, because their opinion does not come in as a as a business record. That is the conclusion. And it might go to the point that was raised earlier that there might have to be some redactions in this document, as opposed to just letting the whole thing come in under the rubric of a business record exception.
Judge Shannon, how do you, in talking with jurors after trials, when they see documents that are redacted, what's their reaction to those documents that are redacted?
Well, my practice is to always thank the jurors, but I do not talk to them about the facts of the case. I have to be mindful that this case may go up on appeal and it may come back to me. So just because there's a ruling, it's not over yet. And so I don't elicit or even accept feedback with regard to things that they liked or things that they didn't like. What I will do, though, is I will explain to the jurors in Fairfax that it is a common practice in our courthouse for attorneys to reach out to jurors to try to get feedback, and that they have no obligation to speak to the attorney, but please don't be offended or think that there's something improper. And I'll tell them that, in fact, I would do this when I was a trial lawyer, and it's a way that we learn what goes on, because while we as a legal community spend all of our time in the profession, very few of us have had the privilege and the opportunity to do what the juries are doing, which is to be in close quarters and to deliberate back and forth. And if we can glean what they found important and not important, it makes us better as a legal community. And that's the way I'll say it to them. I will say that to them in front of the lawyers themselves too, which sort of gives them an invite to reach out to the jurors.
Judge Shannon, I'd like to pose my last question to you, which is, when watching lawyers try their cases in your courtroom, do juries notice when lawyers try their cases with civility and professionalism?
That's a big one. Judges might not know all the nuances of the rules of evidence, and certainly jurors don't. But as human beings, we're pretty good at figuring out when somebody has done something that seems like a cheap shot. And so when it looks like there's discourtesy going on, or somebody's no longer talking to the judge, they're talking at opposing counsel, when it looks like that documents are getting thrown back and forth, you get a sense that this, even things, one's attire. If someone looks like they slept in their suit the night before, they don't have their top button, people make judgments, right? We do CLEs on this stuff all the time, and they want to decide. Jurors want to decide quite quickly which attorney's more credible, and they're going to be looking for cues. And if an attorney comes across as hostile, or if the relation between a judge and an attorney appears strained, I believe they make quick determinations. Now, it might not affect the ultimate ruling, but those initial determinations, those impressions about what they get with regard to the attorneys, I do believe are directly imputed to what they think about the case themselves. And so an attorney's conduct, I believe, has a big effect on their clients themselves. And I don't think any of the lawyers on the panel would disagree with that.
We are ready for final thoughts, and Meredith, you get to start us off.
Sure. So just to echo what Judge Shannon said, years ago, I actually had the privilege of getting to serve on jury because I'm in the district, and if they get rid of all the lawyers, they don't have any jurors anymore. But Judge Shannon's exactly right. I mean, the first break on the first day, people were coming in with opinions about the lawyers based on what they wore, how much time we were sitting around mulling around in the jury room. People were really annoyed about not being able to start on time. They were making assessments about the credibility of the plaintiff based on what he was wearing. And that was the most eye-opening situation of my experience there, which is just, how quickly people jump to conclusions about who to listen to on things that had nothing to do with the actual facts of the case.
Meredith, thank you. Adam.
Yeah, I want to thank everybody. This went really, I thought, really well. Hopefully people enjoyed it. I think the big thing to take away from it is, know the rules the best you can. Know your evidence. do your homework before trial, and that way you'll be ready when these hearsay objections come up, or when you're making a hearsay objection, to have your best arguments. And then, hopefully you have a knowledgeable judge who's going to be able to, respond to your arguments. But the biggest thing is do your homework beforehand. You don't want to be, you're going to be surprised. There's never not going to be a surprise at a trial, but you want to keep the surprises limited. So thank you.
Thank you. Judge Shannon.
What more is there to say? Right. I think this was a really valuable CLE. And to the extent that there's any takeaway, it's that you should be able to articulate on the fly what the particular rule of evidence is, so that a judge can look at the rule, work through the mechanics. As trial judges, we're always thinking about the appellate court reviewing us. And so long as we're working through the rules mechanically, we're going to get a lot of deference. Where we get into trouble is where we either misstate the law, or it's just clear we're not applying the facts to the law in any meaningful way, such that we didn't understand what the law was. So tell us what the rule is and let us work through it.
Thank you. Nick?
Yeah, thank you for these wonderful panelists and this wonderful webinar. I just wanted to make one point about employee statements and how they're so critical in an employment case. There was a case I suggest you all read. It's called Westmoreland versus TWC Administration, LLC, citation 924 F3rd 718. It's a Fourth Circuit case, age discrimination case. And the statement in that case, there was no hearsay issue in the case as far as I could tell, but the statement in that case was, the person delivering the termination message to the terminated employee was, "Oh, girl, you don't have nothing to worry about. You'll get another job. Just go home and take care of those grandbabies." Well, that case resulted in over $600,000 in damages and attorney's fees. That was one fact of the case. But to illustrate the importance of these statements, I think take a look at that case. It's a great one.
Nick, thank you. Josh?
I don't think I have anything to add that everyone else has not hit on, but I do very much appreciate everybody coming out today. It was a great program.
Jane, bring us home.
Gladly, gladly. I just want to thank everybody for coming today. We had a great turnout. I thoroughly enjoyed all the presenters, what they had to say, and it was great to get to know all the other the leadership at the other sponsors, at the other organizations. And I encourage everyone, if they're not a member of the Fairfax Bar Employment Section, to please join and reach out to me. I'm at Warner PLLC in Reston if you want to participate or be a panelist or get more involved in the organization. So thank you so much.
Thanks to Judge Steve Shannon, to Meredith Schramm-Strosser, and a special thanks to Adam Nadelhaft, who organized this webinar for us. Thank you to Jane Lemley, to Nick Simopoulos, Josh Erlich, and our co-sponsors for today's program, the Fairfax Bar Association, Employment Law Section, the Virginia Trial Lawyers Association, and the Virginia Employment Lawyers Association. Mark your calendars for the Metropolitan Washington Employment Lawyers Association's November webinar, co-sponsored by the DC Bar and the Bar Association of the District of Columbia, practicing before the DC Office of Employee Appeals. That's on Thursday, November 20th at 12 p.m. Eastern. For all of our programming from the Metropolitan Washington Employment Lawyers Association, you can find us at www.mwela.org. Thanks for joining us today.